All right. So today we continue our study of contract law. And to do this, let me pull up some of these slides. All right. So I'm going to share this with you. And here we go. All right. So now you see the slides. Again, welcome to week 5. Um, Usually at this point in the semester, I'm like, holy cow, I can't believe we're already to week 5. This semester, I'm like, aren't we done yet? What is going on? Just kidding. I love being with all of you, but all right. But today we'll talk about some of the defenses to contracts. And these deal more with capacity, the ability to enter into a contract. Um, and so obviously, I think it's easy to start with the idea of minors and the idea that minors cannot enter into contracts. Again, we're not talking about Snow White and the Seven Dwarfs, not that kind of mind. I think that's a funnier joke than anybody else. But we're talking about kids. We're talking about in the U.S. 17 and younger, so people that haven't reached the age of 18 yet. Now, what's interesting here is that you know what contracts are, and many of you have entered into contracts today, agreements with others. You've purchased something, you've renewed a lease agreement, whatever the case may be, you've entered into plenty of contracts. And you did this when you were 12 and 6. And anyway, my kids, one of their favorite things to do, and I still don't know that I get this, but their favorite place to eat, other than Righteous Slice, is this little cafe over at the hospital. I think it's called the Paragon. And they just love it. And we live fairly close to the hospital. And so sometimes if my kids have a couple extra bucks, they love walking down to the hospital to go buy a candy bar or a sandwich or something. And so, as you now know, they're entering into contracts, and we allow that. We allow children to enter into some contracts, okay? And what's interesting here is that, like, as you read, kids can enter into contracts, but they can also disaffirm, or in other words, like, get out of the contract when they want to. All right. Now, the exceptions, let's talk about this. Why does the Paragon allow my kids to go over there and buy food? Well, food is considered a necessary. This is something that we need in order to survive. And this has been interpreted rather broadly. It includes food and clothing, medical care, of course. And that makes sense. Like, if we didn't allow kids to enter into contracts for food, or better put, they can enter into a contract but then demand refunds at will, how many people would want to sell kids food? Like nobody. They could just take a bite of the candy bar and say, never mind, give me my buck back. And you could see that would have a chilling effect on the ability of kids to enter into contracts for things that we consider necessary for life. And especially with medical care, like if the doctor's like, I don't know, like we could give this child life-saving treatment, but the child could just disaffirm it later and not pay for it. We don't want that. And so as a result, we allow children to enter into contracts for necessaries. Now, ratification, number 2 here on the list, is an interesting one. And this just means, well, there's really 2 ways to get this. Let's say you enter into a contract to buy a car when you're 17 and like 360 days or whatever. And on your 18th birthday, you keep that car and you don't give it back to the dealership and demand a refund. Well, what you've done is you've ratified that contract as soon as you became the age of majority, in this case 18 in the US. You kept that car, and so now you're stuck with it. Why? Because you ratified it as soon as you became an adult. And this is true for other issues of capacity as well. And then, and the other thing that I was going to mention with ratification is that parents can ratify contracts on behalf of their children. This is how any 17-year-old would ever be able to purchase a car, is typically it's because the parent is co-signing. All right, so that's another thing to keep in mind, is that parents, as the guardian of their own children or adopted children, etc., has the ability to ratify those contracts on behalf of the minor child. And
Berg Hales.
Yeah, Lucas.
Will, will this include like kids that are, for example, working at McDonald's and they're like 14, 15? Will this be included in verification too?
Yes. And yeah, so great question. And really, yeah, so let's stick with that. Many of you, like me, started working when you were under 18. So I think I got my first job bagging groceries when I was 15 or 16. And I entered into an employment contract. Now, that contract was binding, but what it meant is that I could cancel that contract at any time. I could just stop showing up, and I wouldn't be in breach because as a minor, I have the ability to just waive or void any contract that I enter into at any time for any reason. Now, people still hire, uh, in this case, children, people under 18. Why? Because we're cheaper. We are the cheap labor at that point, and it's worth the risk that they've induced me to continue to show up to work bagging groceries because this is one of the few ways that children can make money. And so yeah, that's all allowed. Now my parents didn't have to co-sign my employment agreement. Why? Because this was me personally, and it was worth that risk to Vaughn's. That Vaughn's is the grocery store where I worked, to hire a 16-year-old because they were inducing me to come in enough, and I proved myself worthy for that. So yeah, good question. Now, the rare exception here are the emancipated minors, and that's why I've got a picture of Macaulay Culkin, also known as the Home Alone kid. You know, the whatever. Okay, I'm not going to reenact Home Alone for you, and yet, um, typically, well, not typically, very rarely, uh, children under the age of 18 are allowed to be emancipated from their parents, meaning that they no longer have a legal guardian. They are their own guardian, hence emancipated, and are allowed to enter into contracts for themselves. So Macaulay Culkin at age 16 had more money than I ever will, probably. And so if he went in to buy a car, he could enter into a contract to purchase that car, and the car dealership wasn't worried about him being able to renege or void that contract at a later time because he was emancipated. He lost that ability to do so. And just to show you kind of what a small world that we live in, my girlfriend, freshman year of college, ended up graduating, went out to DC and was working in DC, and then started dating Macaulay Culkin. So I have that connection to the Home Alone star. We dated the same person once. Anyway, stupid story, but kind of cool. All right. Um,
Brother Hales,
yeah, Charlotte.
I have a question. So, like, when I was a sophomore in high school, we had to take the pre-SAT
Yes.
thing saying, like, you won't make memes about this. And then, of course, after we all went home and, like, made memes.
Uh-huh.
And, like, we were all like, oh, well, contracts by minors aren't legally binding. But it's not that they're not legally binding. It's that you can just not do it, right? Or
That's
so
right.
what's like the College Board has to know this, right? Like, so why do they make us sign it if they know we're all minors and we can just make whatever meme we want about it?
Yeah. So great question. I'll turn this back to you. Why do you think they made you do that?
To
What,
try
what,
and scare us into not doing it because they're like, oh, maybe they don't know, and then maybe they'll be afraid to do it.
Charlotte, you're going to be a great lawyer. It's a chilling effect. Yeah, very true. And in fact, there was a recent case, much like your question. It was a ROTC camp. I think this was in North Carolina. They had a number of high school students come to this ROTC camp, and they had ropes courses and, just all kinds of potentially dangerous activities for the kids to do. And they had everybody sign a waiver as they came in. And anyway, one of the waiver said you can't sue us if you're injured, and everybody signed it because they're like, yeah, we want to go on the ropes course, so of course we're going to sign it. And anyway, they didn't think to have the parents sign it, so they only had the kids sign it. And so anyway, when one of the ROTC students ended up injuring herself, she sued the company, or sued the, I should say, the landowner and manager of this ropes course, and ended up winning because by suing the landowner, she had basically, in essence, she had retracted or voided her initial signature to not sue them. So and yet they did that. Why? Because it had a chilling effect. Some people may think like, I got injured, but I can't sue because I signed that waiver, darn it, and they give up. Anyway, you'll see this plenty of times through your life. People will have you sign things that you will now know after taking this class are not binding, simply because it doesn't meet the elements of contract formation, or there's a valid defense to unwind that contract. And that's just one of the reasons that I love teaching contracts, is that this is something that you will use and see forever. So anyway, yeah.
It really helps.
Yeah.
So do you see like any issues in where like the definition of a minor is different like per state, and so then like the application of law becomes different?
No, not anymore. This is standardized. 18 is the age of majority here. Yep.
Other house.
All right. Yeah, Tirza.
How does that work for child stars?
Mm-hmm. So with child stars, they have their guardian sign everything. And so this was true with Macaulay Culkin, just like it's true with any child star today. The legal guardian will sign those contracts, and in fact, it's interesting, especially in the entertainment industry. We'll get to this later on. A child star, technically, even though the parent signs the agreement to fulfill the terms of the agreement. So the example that we use we could use, Harry Potter, those children, the UK operates under the same legal rules here. Any of those children, they signed up to do a number of movies for Harry Potter, and yet they could have pulled out from it at any point. Now, and that's interesting because that's true, even though the parents signed the contract on behalf of the child, it was just a risk that the studio had to take that the child wouldn't pull back on that agreement. And that's a rare exception, because normally if the parent signs for the child may not be liable, but the parent could be as the guardian of that child, and not only the guardian physically of the child, but the guardian of the child's finances as well could be held liable for it. But we'll talk about that more when we get to employment law and labor law in particular. But yeah, just know that typically outside the entertainment world, a parent could be held liable for the child's breach. And so that's why parents should be careful about what they sign on behalf of their children, right? Which kind of leads us into this next slide, dealing with insanity. Now this one I think most of you inherently understand, and that's because insanity, it's a defense to contract formation, because it's a defense saying like the party couldn't enter into this contract, couldn't either offer the original terms of the contract or couldn't accept it. Why? Because they didn't understand what they were offering or accepting. If you don't have the mental capacity to do so, then there's no contract at all. Why? Because it wasn't a valid acceptance or offer in the first place. And what this does is it doesn't mean the contract is void, it just makes it voidable. So here I've got an example of Mitch, student last semester, loved Adam Levine, and let's say that he got that stupid California tattoo across his chest or stomach, whatever it is that Adam Levine did. And why? Because he believed that he was Adam Levine. Well, when he gets the bill, let's say that he didn't pay for the tattoo at the time that it was made or put on him, whatever that is. But he gets the bill for it a week later. Does he have to pay for it? Well, we could talk about this, but I think now you're starting to see that if he didn't understand the nature of what was going on, that he isn't Adam Levine, well, he's got an argument, at least. I'm not saying he's going to win, but he's got an argument that he doesn't have to pay for the contract because he didn't understand the nature of what was happening. And insanity can be something that is more permanent, like some mental deficiency that it has existed since birth and is expected to last through life, or it could be temporary insanity. Now, temporary insanity is going to be difficult to prove because that ebbs and flows. The level of insanity by its very nature ebbs and flows. And so proving that you were insane at the time you entered the contract is going to be difficult. But this is going to be true regardless. I've had clients in Florida that suffered from bipolar disorder. And part of that disorder meant that they would go through manic phases and depressive phases. And when they were on their manic phase, they wouldn't sleep for 3 days. They had visions of grandeur, that they were somebody who they were not. Sorry. My wife did a night shift at the hospital last night, and so I'm banished to the basement and trying to control the kids. Anyway, but what I was saying is some of my clients during this manic phase would go out and buy yachts. And I didn't know this, but like I knew yachts were expensive. I had no idea how much yachts really were down in Miami. They were buying yachts, not for like $2 million. These were like $400 million yachts. And that just is ridiculous how much that is. And so our job was to prove insanity through that manic phase, and that they didn't understand what was happening, and that they couldn't understand their obligations or their responsibilities under this contract. And that is difficult, and it's expensive. You need to fly in psychologists from New York to be able to prove this, and well, to prove it to a jury, to convince a jury that at the time that my client entered into this, they were on a manic phase. Here's the phone records, calling 30 people at 3 a.m., 2 days in a row. Here's the other receipts from other things purchased. Whereas later, that all calmed down. And anyway, again, very difficult.
Florida seems like the worst place to have one of those manic episodes, because it's just a cesspool of bad choices.
That is a good definition or description, I should say, of Miami. Those of you who haven't been to Miami, yeah, it's a different place. It is wild. So,
Brother Hales,
Lucas.
quick question. Would be, if someone is under the influence of any type of drug, will it count to be as insanity, or it's because they did illegal things, it doesn't really count for the law?
Okay, so great question. And that kind of leads us into, it was a perfect question, Lucas. It led us into our next topic here of intoxication. And this can be with alcohol or drugs, and intoxication includes both. And well, you understand this because you saw that clip from Suits when we first started doing contracts, where the guy gambled away his business while playing poker after having so many drinks that he didn't even remember how much he had to drink that night, let alone couldn't remember that he had gambled away his business. And that was the defense that his attorneys were using to show that the contract wasn't valid. Why? Because again, this, Lucas, tell us this, like, could you, in the absence of intoxication, could you gamble away your business through writing on a napkin at the poker table?
You could, if you're desperate, yes, you could.
Yeah, it has all of the elements of contract formation that we need. It's got offer, acceptance, consideration. And that's what, anyway, like you understand that. So again, that doesn't have to be on a notarized sheet with a stamp, wax seal, none of that. You can do it on a napkin at the poker table. But in that specific instance where one party was intoxicated, well, you can see that starts to change things. Now what's interesting is none of you will find yourself, you better not, find yourself intoxicated at a poker table sometime down the road. Like there's so much wrong with this, that living the gospel is going to be such a blessing to your life in so many ways, more than just the spiritual blessings that you receive, but you won't find yourself in these compromising situations as did that individual who, again, gambled away his business at a poker table. But this is difficult to prove. Like, no attorney really wants to take this case to prove that, my client was intoxicated to the extent that he or she could not understand the consequences of his or her actions. I mean, that's difficult, again, requiring expert witnesses. By the way, when you bring in that psychologist, the psychologist or the expert in the field from New York or LA or San Francisco or Houston or wherever it is, these are not cheap. This is a very expensive. They bill by the hour, and it's extremely expensive. So, and again, you're not only proving that they were intoxicated. The purchase records, the receipts from the casino could prove that you were drinking, but you have to prove that you were intoxicated to the extent that you couldn't understand what was going on. And it's usually at the stage that somebody asks maybe what Emma's going to ask. So Emma, go ahead.
Oh, so I was going to ask, back to the story of gambling away the business. So he was surrounded by other people trying to advise him against him and trying to keep him from doing something stupid like that. Even like the dealer of the poker deal sounds like, you sure you want to do this?
Yeah.
And advised against it, and he still does it anyway. It doesn't really count because they weren't like actively trying to get him to do this.
Yeah. So Emma read my mind. This is exactly the question that a lot of you were probably wondering. Like, he was doing this on his own. This was voluntary intoxication. It's not like somebody else put a pill in his drink or something in order to induce him or put him in a situation where he could potentially gamble away his business. He chose, he voluntarily was drinking alcohol. And this is where it's a little controversial, right? Because essentially what we're doing is we're saying the law may protect you from entering into those stupid contracts that you entered into, even though it was your own voluntary, your own volition, your own free will that led you to be in that situation where you did something stupid. And we're still going to protect that person. And the answer is yes. The laws come down on this and said that even though it's voluntary intoxication and you were stupid to be in that situation, if you can still prove that through that intoxication you were unable to understand the consequences of your actions, then we're going to invalidate that contract. It becomes voidable, much like the slide before where we were talking about insanity. Insanity, intoxication come down to the same legal standard. Are you able to understand what you're doing? Are you able to give your full and knowing acceptance to a contract? Are you able to understand the consequences and the terms that you're entering into? If so, you've got a contract. If not, it's going to be voidable by one of these defenses. Now, kind of the difference and the key with intoxication is kind of the second main point here. If the other party doesn't know of the intoxication and it's a fair deal, the contract will be upheld. And that's an interesting exception because, right, like let's say that you buy a car through email and some of you are like, nobody does that. Well, yes, you enter into a contract via email. That happens all the time with most ads and like, let's say you put your car up on Craigslist or KSL and somebody writes in and says, I like your car. I'll pay you. You list it for $50,000 and then they do what they typically do in East Idaho. And they're like, well, I've got $12,000 in cash right now. And you're like, that's not $50,000. Anyway, but let's say that they wrote back and said, would you take 45? And you write back and say, yes. Well, you and I all know we've probably got a contract here because we have an offer and acceptance. And again, it's in writing this time, but that isn't always required. But hold that thought. And so the question is $45,000 a fair deal? Because let's say the person selling the car was intoxicated at the time that they entered into the contract. Well, remember the other party, if they didn't know of the intoxication, so even if you can prove you were intoxicated, you had no idea what you were doing when you replied back via text saying yes, you may very well be intoxicated and normally you could get out of that contract, but the law says if it's a relatively fair deal, and again, you accountants are like, what the heck is a fair deal? Is it within 10% of the offer? Again, sorry, accounting majors. Fair is just what the jury decides is fair. Yeah. So again, to that point, if the other party doesn't know that you were intoxicated, or that the intoxicated party was intoxicated at the time, that deal is going to go through regardless of the fact that they were intoxicated. So this is how we temper the effects of intoxication a little bit as compared to insanity. Insanity doesn't care if you're insane and you say, yes, I'm going to sell my car for 45, you can always get out of that. Whereas with intoxication, you've got this additional test of, did the other party know, or did they have reason to know? That's another element here. All right.
Brother Hells,
Yeah.
going along I don't want to complicate this, but I just want to understand it even better. So what happened is, I have a business partner, and on purpose, I tried to get him drinking to sign a contract.
Okay.
But to a point where he cannot uphold me saying that I intoxicated him, because we're just having a dinner, right? Something like that, and we're just drinking.
Yeah.
And I put up the contract, he signs it, and there were clauses in the contract that because he was a little bit drunk, whatever, he signed it without reading it, and then the next day realized that he made a mistake. In this case, if he takes me to court, would I be able to defend myself saying even though it can be intoxication, it was his free will to drink, and basically he was in a way in a capacity to sign the contract?
Yeah. So again, yeah, don't complicate it too much. If that other party is intoxicated, and especially remember, the jury won't smile on you if they find out that you were the one that was doing the intoxication, right? Again, this is so weird talking about at BYU Idaho. It's different teaching this than at every other school, because you're like, well, I don't drink, and so I don't have to worry about this. But it's important to know the rules nonetheless. So again, assuming, Lucas, you were supplying the alcohol or drugs to somebody else that led them to this intoxication, you knew of it, and it actually goes to show your ill intent with this as well. By the way, I've gotten many of my clients out in Florida out of contracts because of this very same thing. So if you're unfamiliar with timeshares, this is a whole rabbit hole that we don't want to go down right now, but timeshare sales presentations are something that you'll be solicited for sometime in your life. Run. But I had numerous clients who were intoxicated at the time they ended up signing the contract. Now, I probably could have gotten them out of the contract with that alone, but then when it was shown that it was the company themselves, the salespeople themselves, supplying large amounts of alcohol to my eventual client, it just helped show that there was some ill intent here, and that helped get them out of that contract because of it. So now this last statement, ratification, remains true with all of these defenses. If you wake up the next day and you're like, oh, I sold my car for $5,000 less than I wanted. Okay. But if once that happens, you can always ratify contracts entered into during some type of disability or incapacitation. All right. Jeremiah, you've got a question, or Nicholas too.
Jeremiah had his hand raised first, so I'll let him go.
Okay.
Hey, thanks, Nick. So how does the defenses to contracts apply to attorney-client privilege and and the client hiring the attorney?
Okay, so there's a lot there potentially. Do you mean in terms of the what the attorney can and can't say? Is that what you mean by?
Well, so I mean, what if an individual was approaching an attorney who was either could be labeled as insane or intoxicated?
Oh, gotcha.
And so or could an attorney use the defense of constant intoxication and insanity as an excuse to drop the client? Those are my two questions.
So to the second one, yes. And it would just be the same analysis that we've talked about before. The first one's interesting, like representing disabled or incapacitated clients. Legal work is actually considered oftentimes a necessary, meaning that even if they lack the capacity or the age requirement, that those will often be upheld. Why? Because the attorney we hope is acting in the best interest of that client. Now, sometimes if an attorney represents a minor, then of course they'll have the parent or guardian sign the retainer agreement. Or for older disabled or incapacitated individuals, if there is a guardian established by the court, then the attorney will always have the guardian sign. But assuming none of those things, oftentimes those agreements will still be upheld as a necessary, meaning the attorney is doing a valuable or important or necessary legal service, and so the courts will uphold it. All right, Nick, you had a question?
So my question is, you can be far over the limit of legal intoxication for alcohol, and as long as you don't drive, I don't know how it works in casinos and things like that. People get drunk all the time, but I know there's a legal limit. But let's say that somebody was doing meth, an illegal drug, and signed into a contract that they had no idea. And I don't know what meth addict is gonna, in their right mind, like go to an attorney and say like, hey, I was high on meth, but I can't afford to pay this $5 million for this house I bought. And so I guess my question is, when it comes down to a court of law,
yeah, you're admitting to illegal activity is what you're saying.
But they're still going to jail for using meth. Like, how does that work?
Okay, so good question. I'll just say usually not, and the reason is you're bringing this up as a defense in a civil court. It's not like police are waiting outside civil courts for people to admit illegal activity, and so usually that's protected, and your admission of using illegal activities often isn't the basis for a subsequent arrest. Yeah, but good question. It does. Most people shy away from these defenses because of that very fear, and I get that. Okay.
Brother Hills.
Yeah, Daniel.
In the example from Suits, where the guy was drunk and gambled away his company, would the contract be ratified when Harry went back and said, "Hey, I don't think you had a contract here, but we'll throw in $50,000 for your troubles." Would that act be ratifying the contract?
Yeah, Daniel, this is a great question, and the answer is no. So all courts have legally protected negotiations. So if there are negotiations later saying, look, we don't admit that there was a contract, but just to avoid legal expenses and the time that it'll take to put this whole thing through court, we'll give you half of it right now, or something to that effect. And those are never considered an admission at all. As long as it's a good faith negotiation to work out a dispute, it isn't considered an admission. So you don't have to worry about that. In that example, the attorney could go back and say, look, take this money and walk away. It's just in the best interest of everybody to encourage negotiated settlements rather than having everything end up in court. Yeah, really, really good question.
Thank you.
Brother Hales, really fast, a question. Does that uphold if it's a marriage too? Like two people in Vegas, drunk, get married, then they wake up and they're like, oh shoot, we're married. Is that void too? Or do you need to go to court and do like a divorce and all that?
Yeah, marriage is considered a contract. So yeah, that's one of the reasons to nullify a wedding, a marriage. And this differs somewhat by state, but But what you described, yes, that would invalidate a wedding contract. You know, that's kind of weird to think of it like that. Good. Other questions? All right, this one is pretty easy. I enter into a contract with you to injure somebody else. Well, that's illegal, right? And so where there is a contract to do a legal activity, the law just says those are void. Now, this makes sense if you fail to perform your duties under our contract to injure somebody else. Am I really going to sue you and say, look, you know, Sophia was supposed to injure John or something? That doesn't make any sense. So those are just considered void. And in that case, you actually could potentially face some criminal charges for admitting that in court or bringing those charges against somebody. Now, where this gets more interesting is kind of the example that we've got here. My old friend Steve Snow decides he's going to start writing wills, I think is this example. Accountants, they're great, they're wonderful. They can't write wills. It's actually illegal and violates what's known as the, well, rules governing the practice of law. So because he did that in violation of law, well, what's interesting is you could have Steve write up your will and then just not pay him. Why? Because, again, it violates California law in this example. And so, again, get a free will out of accountants that write wills. Although it probably doesn't help. Yeah, Tirza.
Why would that will still be valid if it was written by someone who was not valid to write it?
Good question. And the reason is wills are ascribed to the person whose will it is. And as long as that will has certain language in it, there isn't that much that's required, it's going to be a valid will. Now, we do, at the end of the semester, I do talk about wills and give you advice about wills, give you a blank form that's a will. These are, I guess what I'm trying to say is it could still be a perfectly fine will. And just because the person that helped you create it wasn't an attorney doesn't mean it's not a valid will. It could definitely be a valid will. And Idaho recognizes handwritten wills and guardianships with exceptions. So, like, hang on, we'll talk about that at the end of the semester. But that's the reason it's ascribed to the person whose will it is, not who wrote it. And as long as it's got a couple things in there, it's going to be a valid will. All right. Okay. So right now, we're down to 8 minutes. I'm going to introduce something, and we'll pick this up on Wednesday. You'll read more about it between now and Wednesday. But this is probably the most difficult concept that we cover in the class. And I like to get to it right about now. We're nearing the middle of the semester, because this is just kind of difficult to wrap your head around. And that is the statute of frauds. So let me stop sharing this for a second. And this is how I'm going to introduce it, right? I have drilled into you for the last week and a half this idea that contracts don't need a writing, they can be verbal, they can be a thumbs up, all of that can show evidence that a contract exists. The statute of frauds is going to call me a liar here in a little bit. The statute of frauds is the exception to that general rule. The statute of frauds says, okay, most contracts are fine to be verbal contracts. But in a couple of scenarios, no. In a couple scenarios, we're going to need a writing. Now, keep in mind what I didn't say. I didn't say that we need a written contract. I didn't say that we need a notary. I didn't say a lot of other things that misconceptions that you've heard before. All that I said was that we're going to need a writing or proof that there was an agreement. And not just that we need to prove it in court, 51% sure that I'm right, that there's a contract. No, we're going to actually need some actual writing. Now, what is a writing? That could be a text, that could be a napkin. Like we can meet the writing requirement fairly simple. But the statute of frauds just says, look, certain agreements need a writing. Forget what Brother Hale said last week, like with the head nod and the thumbs up and whatever. That's not going to be good enough. Now we're going to need a writing. So with that in mind, well, you know what? I was going to do a top hat, but I haven't talked enough about this, and you're going to read about it now. So I hope that I've like kind of got you a little bit interested in this subject, because there are just a few exceptions where we're going to need a writing. Really, it comes down to contracts that can't be completed within a year. And that is fun. Like we'll get into some really interesting hypotheticals to show you what that's all about. And marriages contract for a marriage actually has to be in writing, which is odd. It's a carryover from 500 years ago, but it still exists. And then goods over $500. But all of those are going to need a writing. So read that, and then we'll regroup we'll meet on Wednesday and kind of dig into that a little bit more and what that means and how it practically applies. And also some weird, funky exceptions to that rule as well. So again, this is where the course gets complicated, right? Because you've got general rules, then we're going to talk about exceptions, and then we'll talk about exceptions to those exceptions and kind of drill down. And again, you're going to have fun. So again, if you need that, let's see, somebody wants the Top Hat code. That is 0728. Otherwise, let's just call it good for today and then pick up Statute of Frauds on Wednesday. All right. Any last comments or questions before we head out of here? Nick, you got one?
I have a quick question concerning like mental disabilities.
Mm-hmm.
I know that people who are not mentally capable get taken advantage of quite often. Like if you've ever seen the movie I Am Sam, which is a great movie, it just seems like if they knew, they would be able to avoid that contract. Is that true? Because they're not capable mentally to make those contracts. Kind of the same thing. It just goes out the window.
Yeah. So you're exactly right. And this is where there's a disconnect, right? Between the ability to void the contract and the knowledge that you have the ability to void a contract. This is why guardians for those that are mentally disabled become so important, because that's one of their jobs. Like when you become a guardian of a disabled adult, you meet with the judge, and that's part of the process to prove that you, one, know your responsibilities as a guardian, including invalidating contracts that are not in the best interest of the person that you're the guardian of, but also just to watch over them and make sure that you are aware of these things. So yeah, great question. They have to know about it, and otherwise, yeah, people that are mentally disabled do unfortunately get taken advantage of a lot, even sometimes when they have guardians.
Just to clarify, like, so if the contract is illegal, it's automatically voidable. Like you don't need to.
You don't have to do anything. Yeah, you're right. It's just void, like completely. You don't have to do anything.
Even if you've already received like the benefit of what you contracted to do.
Technically, yes. In practical terms, no. You're going to have to go after them to show that they wrongfully got your money. And then you've got the trouble of saying, oh yeah, by the way, it was an illegal contract. Like, yeah, it's just void, but it only helps you so long as you haven't done your part of the contract, if that makes sense.
So like if you contract somebody to burn down somebody else's house, and they burn down somebody else's house, and they come back to you like, okay, where's my money? And you're like, oh, sorry, it's void. Like you
do that.
You get the benefit, and you don't have to pay, and the other person can't sue you.
That's right. But at this point, I'm scared they're going to burn down my house. So
Yeah.
yeah.
Yeah. Then you're dealing with people you don't want to be dealing
Don't enter into those contracts.
with. Okay.
So yeah, there's no legal remedy, but there is additional legal remedies that they could take against you. And it's usually that fear, honestly, of again, like, yeah, you run that risk by entering into illegal contracts.
Right. Okay.
Cool. All right. Thanks, everybody. You have a great day. I'll see you on Wednesday, and we'll get into.
Can I ask some questions?